If you're one of the thousands of families caught in the 75-country visa freeze, 7 out of 10 of you still think your case is frozen right now. And you're wrong. That freeze was actually struck down by a federal judge back in June, but almost nobody has been told. And the mistake people are making right now could cost them months. In this video, I'm breaking down exactly what happened, why the ban is over doesn't mean your visa is coming any day, and the specific steps you need to take this week to actually move your case forward. Right now, if you ask 10 people caught up in the 75-country visa pause what is happening with their case, at least 7 of them will say it is still frozen. They're mistaken. And the fact that they do not know they're wrong is the real story here. Not the pause itself, but what has happened since, and why almost nobody in your position has been told yet. Somewhere tonight, there's a woman in Lagos who was documentarily qualified at the National Visa Center back in March, and she's been checking her case status every single morning since, convinced nothing will move until Washington says so. She's partly correct and partly deeply mistaken. And by the end of this, you'll know exactly why that gap matters for your own case. Whether you're the petitioner, the beneficiary, or someone guiding a family member from thousands of miles away, here's what actually occurred. Stripped of the legal clutter. On January 14, 2026, the State Department announced that beginning January 21st, it would indefinitely pause the issuance of immigrant visas, meaning green cards processed through consulates abroad for nationals of 75 listed countries. Not visitor visas, not F1 student visas, not H-1B, O-1, TN, or E-3 work visas. Only the immigrant visa category, the ones that lead directly to permanent residence. The stated reason was something called public charge, a decades-old and legitimate ground of inadmissibility that asks whether an applicant is likely to rely primarily on government assistance. It is normally reviewed case by case, considering things like income, age, health, and education. What changed in January is that the government stopped handling it case by case. If you held a passport from one of the 75 listed countries, a list covering Latin America, the Caribbean, Africa, the Middle East, parts of Asia, and Eastern Europe, your case simply stopped moving toward final issuance altogether, no matter your finances, health, or job offer on paper. Picture 3 people going through this at the same time. First, a U.S. citizen in Ohio, married to someone from Ghana, with an approved I-130 and a scheduled interview at the embassy in Accra. Second, a software engineer in Bangladesh with an approved EB-2 petition and a priority date that finally became current after a 6-year wait. Third, a graduate student from Pakistan finishing a PhD in the U.S., married to another student, filing an I-485 to adjust status without ever leaving the country. All 3 correctly assumed at the time that they were stuck. The Ohio couple's interview still went forward. DOS never stopped scheduling interviews or taking applications. It simply stopped issuing the visa after that, placing the case into something called 221G administrative processing instead. The Bangladeshi engineer's petition kept collecting dust at the consulate, with no denial and no approval, just silence. And here's the detail almost nobody outside immigration law circles noticed yet. This was not only consular work. Domestically, USCIS quietly extended a version of that same slowdown to I-485 green card applications filed inside the United States by nationals of those same 75 countries, which is exactly the lane your PhD student and her spouse were sitting in. Why did this happen at all? Set aside the political framing you've likely heard and focus on the mechanics, because they matter for what comes next. The administration used a section of immigration law that gives the president broad authority to suspend entry of any class of foreign nationals deemed harmful to U.S. interests. Historically, that authority has been used for things like specific threats from specific regimes. Using it to freeze an entire visa category for 3/4 of the countries on Earth, based on a blanket assumption about public benefit use rather than individual review, was new. And it was legally aggressive enough that a coalition of advocacy groups and affected families filed suit within 2 weeks on February 2, 2026, in federal court in New York, arguing the policy violated both the Administrative Procedure Act, because agencies generally have to give public notice before a change this broad, and equal protection principles, since the list disproportionately affected non-European, non-white populations overall. Before I walk you through exactly what to do if you're caught up in this yourself, if you're finding this useful, go ahead and subscribe so you catch these breakdowns as soon as they drop. The mistake almost everyone made during those first few months wasn't factual. It was behavioral. Families assumed there was nothing to do except wait, so they stopped answering requests for updated documents, stopped renewing medical exams that expire, and stopped keeping the affidavit of support current. Remember, sponsors generally need to show income at roughly 125% of the federal poverty guideline for their household size. And that's a moving figure tied to household size and the calendar year, not something you file once and forget. Some people let police certificates or medical exams lapse thinking, why bother? It's frozen anyway. Others, worse, assumed the pause meant their existing approved petition had been canceled, when in fact, DOS explicitly said no immigrant visas already issued were being revoked, and no approved petitions were being terminated. The cases were paused, not killed. That distinction, paused versus dead, is the single most consequential thing people got wrong, because a paused case that stays document current can move quickly the moment the freeze lifts. A stale case has to restart the clock, and the freeze did lift. This is the part almost nobody has caught up to yet. On June 5, 2026, a federal judge ruled that the pause on immigrant visa and adjustment of status processing for nationals of these 75 countries was unlawful and ordered the relevant agencies to lift it. The July 2026 visa bulletin cycle reflected that ruling, effectively restoring normal country-by-country processing rather than the blanket freeze. That's not a rumor. That's a documented court order, and it happened roughly 6 weeks before you're watching this. Meanwhile, a second, separate legal effort, a proposed class action seeking additional remedies under different legal theories, was set for filing on July 10th, aimed at making sure people whose cases were refused or shelved during the freeze get a real path back into the queue, rather than being told to start over from scratch. So, here's your open question answered. The reason this matters more than the freeze itself is that a court order lifting a policy does not automatically mean every consulate, every visa officer, and every USCIS field office has caught up in practice. Court rulings restore the legal duty to process your case normally. They don't handle a fixed timeline for your specific file. That's the trap right now. People think the ban is over means my visa is coming any day. What it actually means is that the artificial blockage is gone, and my case goes back to being evaluated on its own facts, at whatever pace that consulate or field office is running currently. For the Ohio couple, that likely means their 221G case gets re-reviewed, and, absent an actual individualized public charge concern, moves toward issuance. For the Bangladeshi engineer, it means the petition that sat untouched should now be adjudicated like any other pending EB2 case in the queue. For the PhD student adjusting status domestically, it means her I-485 goes back into USCIS's normal processing rhythm, rather than the special hold. Though normal processing for adjustment cases still commonly runs many months, so patience is still required, just not endless, open-ended waiting. If you're in any version of this situation, here's what I'd actually tell you to do. Don't wait for a letter to arrive confirming the freeze is over. Go check your case status yourself this week. Whether that's through the National Visa Center portal, the consulate's own system, or your USCIS online account, because the burden has quietly shifted back onto you to keep your file document current. Renew anything that's expired. Medical exams typically run out within roughly 6 months to a year, depending on the civil surgeon's findings. Police certificates and affidavit of support need to reflect current addresses and current income. If your case was refused or placed in prolonged 221G status, specifically because of the country-based pause rather than an individual finding against you, that's worth flagging to counsel now while the class action window is active, rather than assuming it will sort itself out. And if you've simply been sitting quietly, assuming nothing can move, that assumption just became the most expensive thing in your case. If this is where you are right now, I know it doesn't feel simple. And I know the court fix doesn't feel like enough when you're the one still checking a portal every single morning. But the practical truth is this. The freeze that felt permanent in January was never truly permanent. And the version of you who keeps your documents current and checks your status proactively right now is going to move through this system months faster than the version who waits for someone to tell them it's safe to act. Follow for more updates like this one, and subscribe to the channel so you don't miss what's coming next.